Hello, so I'll be talking on equal pay for equal work. The constitutional principle of equal pay for equal work has been upheld by the Supreme Court of India with respect to temporary employees vis-a-vis permanent employees in the government sector. In state of Punjab, the Supreme Court has ruled that temporary employees performing similar duties and functions as discharged by permanent employees are entitled to draw wages at par with similarly placed permanent employees. The principle must be applied in situations where the same work is being performed irrespective of the class of employees. Now the facts behind it. The instant case arose out of conflicting judgments of the Punjab and Haryana High Court. The court has analyzed the question as to whether temporary employees, daily wage employees, ad hoc appointees, employees appointed on casual basis, contractual employees, and the like are entitled to the same wages as that of permanent employees if they discharge similar duties and responsibilities as that of permanent employees. The court took the view that temporary employees would not be entitled to the minimum of the pay scale as was being paid to similarly placed permanent employees. However, the court took a contrary view that held temporary employees would be entitled to minimum of the pay scale along with permissible allowances as revised from time to time, which were being given to similarly placed permanent employees. Given the conflicting views, the matter was referred to a full judge bench of the Punjab High Court. The full judge bench of the High Court, while adjudicating upon the issue, concluded that temporary employees are not entitled to the minimum of the regular pay scale merely on account of the reason that the activities carried out by daily wages and permanent employees are similar. However, this rule was subjected to two exceptions, wherein temporary employees would be entitled to wages at par with the permanent employees. If the temporary employees has been appointed in a regular sanctioned post after undergoing a selection process based on fairness and equality of opportunity to all other eligible candidates. Second, if the temporary employees has been appointed in a post which is not a regular sanctioned post, however their services have been availed continuously with notional breaks for a sufficient long period. The instant case before the Supreme Court arises out of a challenge raised against all the three judgments. Start. Analyzing in length the principles laid down by various courts, the Supreme Court observed that the issue at hand, a bird's eye view on the underlying ingredients which govern the principle of equal pay for equal work. The principle has been extensively deliberated in a decision in order to make the determination. The Supreme Court examined the situations where the principle was extended to employees engaged on permanent basis and thereafter the situation in which the principle was extended or declined to different categories of temporary employees. Accordingly, various principles have been discerned and distinguished by the Supreme Court. Analyzing claims by temporary employees under the principle, the Supreme Court observed not paying the same wages despite the work being the same is violative of Article 14 of the Constitution of India and amounts to exploitation in a welfare state committed to a socialist pattern of society. Second, the right of equal wages claimed by temporary employees emerges from Article 39 of the Constitution. The third would be the claim for equal wages would be sustainable where an employee is required to discharge similar duties and responsibilities as permanent employees and the concerned employee possesses the qualifications prescribed for the particular post. Fourth would be in a claim for equal wages, the duration of which an employee remains or has remained engaged, the manner of selection or appointment, etc., would be insofar as the applicability of the principle is concerned. Fifth would be based on the principle flowing from Article 38 of the Constitution. The government cannot deny a temporary employee at least the minimum wage being paid to an employee in the corresponding regular cadre, along with dearness allowance and additional dearness allowance as well as other benefits which are being extended to casual workers. Sixth would be the classification of workers as unskilled, semi-skilled and skilled. Doing the same work into different categories for payment of wages at different rates is not tenable. Such an act of the employer would amount to exploitation and shall be arbitrary and discriminatory and therefore violation of Article 14 and 16 of the Constitution. The last would be if daily wage employees can establish that they are performing equal work of equal quality and that all the other relevant factors are fulfilled, a direction by a court to pay such employees equal wages from the date of filing the writ petition would be justified. The Supreme Court observed that an employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities and certainly not in a welfare state. Such an action, besides being demeaning, strikes at the very foundation of human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He or she does so to provide food and shelter to his family at the cost of his or her self respect and dignity, and also at the cost of his or her self worth. Any act of paying less wages as compared to others similarly situated constitutes an example of exploitative enslavement emerging out of a domineering position. Undoubtedly, the action is oppressive, suppressive, and coercive as it compels involuntary subjugations. The Supreme Court further observed that India, being a signatory to the International Covenant on Economical, Social, and Cultural Rights 1966, there is no escape from the obligations thereunder in view of the different provisions of the constitutions. Thus, the principle of equal pay for equal work constitutes a clear and unambiguous right and is vested in every employee, whether engaged on a permanent or temporary basis. Accordingly, the Supreme Court set aside the decisions rendered by the full judge bench of the Punjab High Court and the divisions bench in state of Punjab. While the decisions of the division bench in state of Punjab was upheld, subject to the modifications that the concerned employees would be entitled to the minimum of the pay scale of the category to which they belong, but would not be entitled to allowances attached to the posts held by them. This judgment is indeed a welcome step and provides the right direction in terms of ensuring equality. Non permanent employees are meant to be used only for business exigencies and not for wage arbitrage. Unfortunately, there continues to be instances of discrimination of such non permanent staff in India, especially contract labor, which discrimination must be avoided at all costs. In fact, the Contract Labor Regulation and Abolition Act 1970 requires the contractor to ensure that the rates of wages payable to the workmen of the contractor are not less than the rates prescribed under the Minimum Wages Act 1948. The Supreme Court judgment should, in our view, help change the way employees approach such non permanent staff, leading to significant reduction in wage discrimination. Having traversed the legal parameters with reference to the application of the principle of equal pay for equal work in relation to temporary employees, the most important factor that would require determination is whether the concerned employees are rendering similar duties and responsibilities as are being discharged by permanent employees holding the same corresponding posts. This judgment of the Supreme Court makes it clear that a mere difference in nomenclature is not sufficient to disentitle a temporary employee from being paid wages at par with permanent employees. That's all.